In this part 38, we will continue our discussion regarding trial before a court of session, which we have started by taking into consideration right from section 225 up to section 237 of the Criminal Procedure Code. Now, in the last lecture, while we were dealing with section 235, we have learned this section is to be read along with section 361 of the Criminal Procedure Code for the simple reason, if the judgment is that of an acquittal, the trial ends there. But if the judgment is that of conviction, then judge is bound by law to observe the law that is laid down as far as the Probation of Offenders Act of 1958 is concerned. Now, if you have read this section 361, now it's not necessary for you to read the provisions of section 360 of the Criminal Procedure Code because of section 19 of the Probation of Offenders Act of 1958, which is made applicable. And then as far as the juvenile is concerned or the child is concerned, where instead of reading any one of the provisions, you have to refer to the provisions of the Juvenile Justice, Care and Protection of Children Act of 2000 in order to make everything clear for the purpose of understanding. And if the judge doesn't proceed, maybe as per the provisions of the Probation of Offenders Act or of 1958 or the Juvenile Justice, Care and Protection of Children Act of 2000, then the order is that of conviction as far as section 235 of the Criminal Procedure Code is concerned. And then if you read section 236, which says, in a case where a previous conviction is charged under the provisions of subsection 7 of section 211 and the accused does not admit that he has been previously convicted as alleged in the charge, the judge may, after he has convicted the same accused under section 229 or section 235, take evidence in respect of the alleged previous conviction and shall record a finding thereon, provided that no such charge shall be read out by the judge, nor shall the accused be asked to plead thereto, nor shall the previous conviction be referred to by the prosecution or in any evidence adduced by it, unless and until the accused has been convicted under section 229 or section 235 of the Criminal Procedure Code. And hence this is to be read along with section 298 of the Criminal Procedure Code, which deals with evidence in inquiries and trials. And it says, in any inquiry, trial or other proceedings under this code, a previous conviction or acquittal may be proved in addition to any other mode provided by any law for the timing in force, by an extract certified under the hand of the officer having the custody of the records of the code in which such conviction or acquittal was held, to be a copy of the sentence or order in any case of conviction, either by a certificate signed by officer in charge of the jail in which the punishment or any part thereof has been undergone, or by production of the warrant of commitment under which the punishment was suffered, together with in each of such cases evidence as to identity of the accused person with the person so convicted or acquitted. So this is as far as section 235 is concerned. And then we come to the last part, and that is, once we have dealt with section 236, this is the trial before a court of session, with which we started right from section 225 onwards of the Criminal Procedure Code. But this trial is with respect to when the cognizance of an offence is not taken by the court of session, but case is committed to the court of session as far as section 209 of the Criminal Procedure Code is concerned. Whereas the last section, namely section 237, deals with the cases when the cognizance of an offence is directly taken by the court of session as per section 199 subclause 2 of the Criminal Procedure Code with which we dealt, where we learn that this is the only exception. Cognizance of an offence is always taken by the court of magistrate, whereas section 199 subclause 2 is the exception where the cognizance, the only exception where the cognizance is directly taken by the court of session. Now, what is the procedure? In cases instituted under section 192 subclause 2 is made very clear as far as section 237 is concerned, which says, a court of session taking cognizance of an offence under subsection 2 of section 199 shall try the case in accordance with the procedure for trial of a warrant cases instituted otherwise than on police report before a court of magistrate. Now, what is the procedure as far as the trial of a warrant case which is instituted otherwise than on police report, with which we shall be dealing as far as the next trial is concerned, when we shall be starting right from section 238 up to section 250 of the Criminal Procedure Code. Hence, now further part it says, provided that the person against whom the offence is alleged to have been committed shall, unless the court of session for reasons to be recorded otherwise direct, be examined as a witness for the prosecution. Subclause 2 says, every trial under this section shall be held in camera if either party dares to so desires, or if the court thinks fit so to do. Clause 3 says, subclause 3 says, if in any such case the court discharges or acquits all or any of the accused and is of the opinion that there was no reasonable cause for making the accusation against them or any of them, it may, by its order of discharge or acquittal, direct the person against whom the offence was alleged to have been committed, other than the president, vice president, or the governor of a state or the administrator of the union territory, to show cause why he should not pay compensation to such accused or to each or any of such accused when there are more than one. Subclause 4 says, the court shall record and consider any cause which may be shown by the person so directed, and if it is satisfied that there was no reasonable cause for making the accusation, it may, for reasons to be recorded, make an order that the compensation to such amount not exceeding 1,000 rupees, and it may determine, be paid by such person to the accused or to each or any of them. Subclause 5 says, compensation awarded under subsection 4 shall be recorded as if it were a fine imposed by a magistrate. Subclause 6 says, no person who has been directed to pay compensation under subsection 4 shall, by reason of such order, be exempted from any civil or criminal liability in respect of the complaint made under this section, provided that any amount paid to an accused person under this section shall be taken into account in awarding compensation to such person in any subsequent civil suit relating to the same matter. Subclause 7 says, the person who has been ordered under subsection 4 to pay compensation may appeal from the order in so far as it relates to the payment of compensation to the High Court. Subclause 8 says, when an order for payment of compensation to an accused person is made, the compensation shall not be paid to him before the period allowed for the presentation of the appeal has elapsed, or if an appeal is presented before the appeal has been decided. So this is section 237 of the Criminal Procedure Code. Now we intend to start with the trial of warrant cases by magistrate right from section 238 up to section 250 of the Criminal Procedure Code. While dealing with this trial, we shall try to understand that this trial there are two trials as far as this chapter is concerned. One, trial of a warrant case which is instituted on police report, and then trial of a warrant case which is instituted otherwise than on police report. So we will understand this chapter by taking into consideration the procedure regarding trial of a warrant case which is instituted on police report and trial of a warrant case which is instituted otherwise than on police report. And then once we finish with this, naturally we will proceed to a trial of a summons case and then the summary trial, that is the last trial as far as the Criminal Procedure Code is concerned. But as we have dealt with the trial before a court of session, right from section 225 up to section 237, this is a time for me to tell you and refresh your memory regarding all the sections with which you have dealt so far, namely not only from 225 to section 237, but simultaneously we had cross references to many sections, and hence once you correlate these sections with the rest of the sections, now I need not repeat whatever is dealt by us at the time of dealing right from section 225 onwards. For example, when we were dealing with this, we learned that trial is always conducted in open court, section 327. When we talk about recording of the evidence, then recording of the evidence must take place day to day, as for which I had drawn your attention to section 309. When we talk about evidence, there can be evidence on behalf of the prosecution, there can be evidence on behalf of the defense, but then the section 311 deals with a case where there can be evidence of a witness who is neither called by the prosecution nor by the defense, but is called by the court of law, namely court witness. If the situation is such that there must be a local inspection is carried out as far as section 310 of the Criminal Procedure Code is concerned. When we talk about recording of the evidence, the manner in which a record is required to be kept will entirely depend upon the nature of the trial, whether it is a trial as far as the trial before a court of session is concerned, 276, trial of a warrant case, 275, trial of a summons case, section 274, whereas as far as the trial in a summary trial is concerned, we shall be dealing with section 264. During this, what happens if the evidence is recorded in the language of the court and that the language of the court is not at all understood by the person, namely the accused person in a court? Then we are guided right as far as section 279 of the Criminal Procedure Code is concerned, which deals with provision regarding interpreter, and rest of namely section 277, section 278, and then remarks regarding demeanor as far as section 280 with which we have dealt. Now when the accused person is examined, when evidence on behalf of the prosecution is over, it is the duty of the court shall examine the accused person, and for the purpose of examining the accused person, court is guided by taking into consideration the provisions as far as section 313 to be read with section 281 of the Criminal Procedure Code is concerned, with which you are dealt. In other words, now the provisions with which you have dealt so far need not be repeated at the time when we deal with the various trials, but this is exactly what you have to take into consideration. When the witness is in the witness box, he will have to undergo examination in chief, cross-examination and re-examination, for which you will have to refresh your memory by reading section 137 of the Indian Evidence Act to be read with section 138 of the Indian Evidence Act. Whenever the examination goes on, as whether is it possible for the advocate to put him questions, and for that I mean leading questions, and for that you have to refer to section 141, 142 and 143 of the Indian Evidence Act. So accordingly, now this is, I mean to say, this is enumeration. The list is not at all exhaustive. As and when it is possible, it is must, for example, it is must for you to have understand the provisions in the context. For example, we said that there, yes, presence of the accused person, depending upon the trial, unless the presence has been dispensed with, is made very clear as far as section 273 of the Criminal Procedure Code is concerned. The language of the court is made very clear as far as section 272 of the Criminal Procedure Code is concerned. Yes, but even though the accused person is present, and if it happens that accused person who is present has become a person of unsound mind, is not in a position to understand the proceedings which are going on in a court of law as far as the state of the mind is concerned. He was person of sound mind at the time when the act was done by him. If he was a person of unsound mind at the time when the act was done by him, then he is protected provided he suffers because of what is known as legal insanity as far as section 84 of the Indian Penal Code is concerned. But he was a person of sound mind at that time, but now if he becomes a person of unsound mind, then naturally, so you are guided right from section 328 up to section 339, which deals with these are the provisions with respect to accused person of unsound mind. And there we are told, irrespective of the nature of the trial is adjourned or postponed till he becomes a person of unsound mind. So these are some of the provisions I said, and then as we go on learning, now this is the time I want to make it very clear that simultaneously, along with right from section 225 up to section 237, we have dealt with many more sections. Hence, this is the time, and there should not be, I personally feel that there should not be any confusion for the purpose of correlating these sections. But then what is, if you straightway start talking about the provisions as far as trial before a court of session is concerned, then it says, in every trial before a court of session, the prosecution shall be conducted by public prosecutor. And then the sections I hope you remember. When accused appears or is brought before the court in pursuance of commitment of a case under section 209, the prosecutor shall open his case by describing the charge brought against the accused and by stating by what evidence he proposes to prove the guilt of the accused. If, upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing. If after such consideration and hearing as aforesaid, the judge is of the opinion that there is a ground for presuming that the accused has committed an offence which is not exclusively triable by the court of session, he may frame a charge against the accused and by order transfer the case for trial to the Chief Judicial Magistrate or any other Judicial Magistrate of the first class, and direct the accused to appear before the Chief Judicial Magistrate, or as the case may be, the Judicial Magistrate of the first class, on such date as he deems fit, and thereupon such magistrate shall try the offence in accordance with the procedure for the trial of warrant cases instituted on police report. If it is exclusively triable by the court, he shall frame in writing a charge against the accused. Where the judge frames any charge under subclause B of section 1, the charge shall be read and explained to the accused, and the accused shall be asked whether he pleads guilty of the offence charged or claims to be tried. With this then, if the accused pleads guilty, the judge shall record the plea and may in his discretion convict him thereon. If the accused refuses to plead, or does not plead, or claims to be tried, or is not convicted under section 229, the judge shall fix a date for the examination of witnesses and may, on the application of the prosecution, issue any process for compelling the attendance of any witness for the production of any document or other thing. On the date so fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution. The judge may in his discretion permit the cross-examination of any witness to be deferred until any other witness or witnesses have been examined, or recall any witness for further cross-examination. If after taking the evidence for the prosecution, examining the accused and hearing the prosecution and the defense on the point, the judge considers that there is no evidence that the accused committed the offence, the judge shall record an order of acquittal. Where the accused is not acquitted under section 232, he shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. If the accused puts in any written statement, the judge shall file it with the record. If the accused applies for the issue of any process for compelling the attendance of any witness or production of any document or thing, the judge shall issue such process unless he considers for reasons to be recorded that such application should be refused on the ground that it is made for the purpose of vexation or delay or for defeating the ends of justice. When the examination of the witnesses, if any, for the defense is complete, the prosecutor shall sum up his case and the accused or his pleader shall be entitled to reply, provided that where any point of law is raised by the accused or his pleader, the prosecution may, with the permission of the judge, make his submission with regard to such point of law. After hearing arguments and points of law, if any, the judge shall give a judgment in a case. If the accused is convicted, the judge shall, unless he proceeds in accordance with the provisions of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. In any case where a previous conviction is charged under the provisions of subsection 7 of section 211, and the accused does not admit that he has been previously convicted as alleged in the charge, the judge may, after he has convicted the same accused under section 229 or section 235, take evidence in respect of the alleged previous conviction and shall record a finding thereon, provided that no such charge shall be read out by the judge, nor shall the accused be asked to plead thereof, nor shall the previous conviction be referred to by the prosecution in any evidence adduced by it, unless and until the accused has been convicted under section 229 or section 235. And then the last point is the procedure that is required to be followed by the Sessions Court in cases instituted under section 199 subclause 2 of the Criminal Procedure Code. With this, we have come up to section 237, and during next lecture we shall start dealing right from section 238 up to section 250 for the purpose of understanding procedure of trial cases by magistrate.